How do top lawyers persuade without sounding aggressive, uncertain, or vague? In this advanced legal English class, we'll focus on how to structure legal arguments clearly, respectfully, and strategically. You'll learn high impact vocabulary for persuasion, along with advanced grammar tools like inversion and formal register, perfect for legal professionals who want to frame arguments with precision and professionalism. This is part of our full legal English course for lawyers and legal professionals. If you want access to all the lessons plus community support and practice, join us in our community. The link is in the description. Today's lesson is about strategic language. Whether you're defending a client or advising one, how you frame your argument matters just as much as the content. We'll explore advanced tools like inversion and formal register that help you sound more credible, authoritative, and persuasive. You'll also build vocabulary for legal reasoning, helping you present points clearly, logically, and respectfully in professional conversations. What actually makes a legal argument persuasive? It's more than just confidence or legal knowledge. A persuasive legal argument is built on logic and legal reasoning, but it's also delivered with control, precision, and respect. You need emotional control to avoid sounding aggressive and a formal, respectful tone to show professionalism, especially in high-stakes negotiations or courtroom settings. You are not just stating your case, you're guiding your audience toward your client's position. Effective legal speakers anticipate counter-arguments and address them head-on. They use clear structure and transitions to organize their reasoning. They speak with authority, back claims by presenting evidence, and never lose sight of the client's objectives. Let's warm up by completing some of the thoughts together. One element of persuasive legal language is anticipating counterarguments before the opposing side raises them. This allows you to stay in control of the conversation and build credibility. If your tone is too emotional, your legal reasoning may be undermined, and your argument may come across as unprofessional. Remember, persuasive doesn't mean passionate, it means precise. Strong arguments usually include structured logic, clear transitions, and evidence tied directly to the client's goals. We'll now explore the specific language and grammar structures that help you to do this naturally in English. Let's get started. Let's start with vocabulary. And first up is persuasive language. Persuasive language refers to the strategic use of words and tone to guide someone's thinking. In legal conversations, this doesn't mean being manipulative. It means helping clients or opposing counsel see the logic in your position. Take this example. We strongly recommend this course of action based on the facts and legal precedent. This phrase builds trust. It shows you're not just giving an opinion, you're grounding your advice in the law. Imagine you're advising a business client considering two settlement options. You don't say option B is better. You say, we strongly recommend option B as it aligns with established precedent and minimizes long-term exposure. That's persuasive and professional. Throughout this lesson, you'll learn how to choose words that are clear, calm, and convincing, even under pressure. Now, let's talk about legal reasoning, the backbone of persuasive legal communication. Legal reasoning means connecting the dots between the law and the facts. It's not just about stating what happened, it's about explaining why that matters, using the legal framework to guide the listener to a conclusion. For example, given the breach and the lack of notice, we believe liability is likely. This isn't emotional, it's calm, structured, and backed by law. Imagine a client asks if they have grounds to terminate a contract. Instead of a vague answer, you walk them through it step by step. The other party failed to deliver on time, which constitutes a material breach. Based on Section 10 of the agreement, that breach gives us the right to terminate. This kind of response builds confidence and clarity. Your legal reasoning shows not just what you recommend, but why. In any legal discussion, you can't just build your own case. You also need to anticipate the other sides. That's where the concept of a counterargument comes in. A counterargument is a possible objection or opposing view. Skilled lawyers think two steps ahead. They identify these challenges and prepare responses in advance. Let's say you're advising a client who wants to enforce a contract clause. You might say, one possible counterargument is that the clause was never enforced in previous cases. However, we have evidence that both parties acknowledged it in writing last year. Here, you're not just reacting. You're framing the conversation proactively, showing the client that you've considered all angles, and that's what builds trust and credibility in legal communication. In courtroom advocacy or negotiations, this approach is vital. You present your position, address the counterargument, and then explain why your view remains the stronger one. Let's talk about a foundational concept in legal reasoning, the burden of proof. This phrase, burden of proof, refers to who must prove what in a legal dispute. In civil cases, it is usually the plaintiff who carries the burden. They must provide enough evidence to convince the court that their claim is valid. For example, imagine a client wants to sue for breach of contract. You might say, the burden of proof lies with the plaintiff to establish that the contract was breached. That means your client needs documentation, witness statements, or other credible evidence. Understanding this concept shapes your legal strategy. What evidence do you need to gather? How strong is your case based on what you can prove, not just what you believe? Communicating this clearly to clients helps them manage expectations, understand legal risks, and make better decisions about proceeding. In legal conversations, especially in adversarial contexts, you often need to disagree without sounding aggressive. That's where the word rebuttal becomes useful. A rebuttal is a strategic response, not just a disagreement, but a well-reasoned reply that undermines the other party's argument using facts, logic, and/or legal precedent. For example, suppose opposing counsel claims your client breached a contract. You might say, her rebuttal emphasized that the client had acted within the terms of the agreement. This isn't just denying the claim, it's presenting a counter-narrative grounded in evidence and framed with precision. Effective rebuttals require emotional control so you don't sound defensive, a formal tone even when pointing out flaws, and a structure. Acknowledge the point, then redirect with logic and legal reasoning. Mastering rebuttals means you can stand your ground while maintaining professionalism, a key skill in both litigation and negotiation. In legal communication, what you say matters, but how you say it often matters more. This is the power of framing. Framing refers to the strategic presentation of facts, questions, or arguments to guide how others interpret a situation. You're not changing the facts, you're changing how the facts are seen. Let's say your client took a risky business decision. You could present it as reckless, or you could reframe it as the attorney's framing of the facts made the client's position seem both reasonable and compelling. She didn't lie. She highlighted motivations, context, and the client's diligence, all to lead the listener toward a more favorable understanding. Framing is about shaping perception without distorting truth, emphasizing strengths while downplaying weaknesses, aligning your argument with client objectives, whether you're talking to a judge, opposing counsel, or even the nervous client. Framing helps you stay persuasive, composed, and in control of the conversation. Imagine this. You're advising a client in a workplace discrimination case. The opposing side describes it as miscommunication, but you open the discussion by stating this is a case about consistent bias and unequal treatment over time. You've shifted the narrative from a minor issue to a systematic problem. What do we call that technique when we strategically shape how a case is viewed? The answer is framing. Framing is about shaping perception. A well-framed argument puts your client's story front and center, not just the facts, but how those facts feel and function within the legal context. In a real estate dispute, the seller claims your client delayed the payment, breaching the contract, but you produce emails and bank records showing that the seller failed to provide the correct wire instructions, making timely payment impossible. You're not just defending, you're dismantling their claim. What is this kind of pointed legal response called? A rebuttal. A rebuttal doesn't just deny, it responds. It uses facts and logic to flip the weight of the argument and show the other side's claim doesn't hold up. You're in mediation for a breach of contract case. The plaintiff says your client never delivered services, but they haven't shown invoices, communication, or any attempt to follow up. Your response is simple. They made the allegation. Now they must prove it. What legal concept are you referring to? The answer is burden of proof. The burden of proof lies with the party making the claim. In civil cases, this usually means showing evidence that supports their version of the story. It's a cornerstone of fairness in legal process. In a zoning appeal, the opposing lawyer argues that approving your client's project would increase traffic congestion. You respond with studies showing that the development actually reduces pressure on surrounding roads due to planned infrastructure upgrades. You didn't ignore their point, you met it head on. What is this strategy called? A counter-argument. And a counter-argument is a critical part of strong advocacy, not just asserting your case, but addressing the weaknesses in the other side's logic before they become roadblocks. In a visa denial case, you don't just say the officer made a mistake. You cite the exact section of the immigration code, interpret how it's been applied in prior cases, and explain why the evidence submitted meets the standard. You're not improvising, you're constructing logic. What's the name for this kind of structured analysis? It is legal reasoning. And legal reasoning is the disciplined logic that holds a legal argument together, applying precedent, statutes, and facts to produce persuasive, defendable conclusions. A client wants to sue a former business partner, but litigation would be costly and public. You craft an email that doesn't threaten, but suggests. Given the uncertainty of court outcomes and the costs involved, we believe an amicable settlement serves both sides. You're nudging, not pushing. What kind of language are you using? You are using persuasive language. And persuasive language blends professionalism with subtle influence. It's how legal professionals guide conversations, not with force, but with strategy and diplomacy. In legal conversations, especially in formal or persuasive situations, how you emphasize a point can completely change how it lands. That's where inversion comes in. It's when you flip the sentence order to give a statement more weight or formality. Compare these two. This issue has never been raised before. Never has the issue been raised before. The second version sounds more emphatic, more authoritative. That's exactly the tone you often need in courtrooms, hearings, or negotiations. Here are a few more legal examples. At no point did the client receive proper notice. Only after reviewing the records did we discover the breach. Under no circumstances should this clause be interpreted loosely. We'll practice how to use inversion in structured arguments shortly, but remember, inversion equals control, formality, and impact. Let's practice how inversion helps us sound more precise and persuasive in legal contexts. Below are 3 typical legal statements. Your job is to rephrase them using inversion for extra emphasis. Let's try the first one. The client was never informed of the change. 2. Never was the client informed of the change. Going on to the next one. We only discovered the error after the settlement. Only after the settlement did we discover the error. They didn't consider the plaintiff's rebuttal at any point. At no point did they consider the plaintiff's rebuttal. In each case, inversion adds weight. It's no longer a neutral observation. It becomes a pointed, authoritative claim. And that's often what legal advocacy requires. Now, let's turn to formal register, a key element of persuasive legal English. In courtroom or negotiation settings, you're not just speaking politely. You're using a strategic tone that commands respect, avoids confrontation, and builds credibility. Take these examples. Instead of saying, you have to prove it, a lawyer should say, the burden of proof lies with the claimant. It's formal, neutral, and legally precise. Rather than, that's not true, you might hear, this assertion is not supported by the evidence. This distances the speaker from emotional reactions and focuses on fact. Instead of saying, we think the contract is unfair, you could say, it is respectfully submitted that the contract is unconscionable. And instead of saying, we think the contract is unfair, you could say, it is respectfully submitted that the contract is unconscionable. This adds professionalism and legal weight to your position. In this lesson, we'll continue practicing how to shift your language into a persuasive formal register, especially when presenting arguments, rebuttals, or counterpoints. Let's practice turning informal reactions into persuasive formal legal language. Imagine you're in a courtroom or writing a legal opinion. These aren't casual conversations. You want to sound measured, professional, and authoritative. Try transforming these. That's not fair. You could say, this provision appears to be inequitable given the surrounding circumstances. You're wrong about the facts. Try, with respect, the factual basis of that argument appears to be inaccurate. We don't agree with that. Shift it to, our position differs on this matter, based on the following legal reasoning. You didn't give us enough evidence. A more formal version is, the evidence provided does not sufficiently support the claim as presented. In real legal conversations, whether in court or during negotiation, this tone shows not only respect, but confidence. Clients, judges, and opposing counsel are far more likely to listen when your language stays calm and elevated, even when the stakes are high. In legal discussions, the phrase call into question is used when someone challenges the reliability, legality, or truth of a claim, fact, or person. Let's say you're advising a client whose signature appears on a disputed contract. The other party insists the signature is real, but your client maintains it was forged. When you present evidence that the document may have been altered, you're not just making a casual comment. You're calling into question the entire validity of the agreement. This idiom is powerful because it implies that something fundamental may be flawed or untrustworthy, a common tactic in both litigation and negotiation. It's a formal but strategic way to shift the burden back onto the opposing party. To draw a clear distinction means to clarify differences that matter, especially when two ideas might otherwise be misunderstood or conflated. Imagine you're representing a company accused of breach of contract. The plaintiff is framing it as intentional deception, but your client misses a deadline due to supply chain issues. In your legal argument, you draw a clear distinction between a willful breach, which could carry punitive damages, and a delay caused by external factors, which may only merit minimal consequences. This idiom shows that you're precise in your reasoning. In legal context, it helps a judge, jury, or opposing counsel see that your position is more reasonable, more nuanced, and ultimately more persuasive. To put forward a compelling case means to present your legal argument in a way that is thorough, logical, and persuasive, with enough weight to convince the decision maker. Picture this. You're representing a whistleblower in an employment dispute. The employer claims there was a justified termination, but you've gathered emails, witness statements, and labor code citations. During the hearing, you put forward a compelling case that your client was dismissed in retaliation for reporting unsafe practices. This phrase emphasizes structure and strength. A compelling case isn't just emotional, it's strategic. You use evidence, legal reasoning, and clarity to show not just what happened, but why it matters under the law. In advanced legal English, this is the language of winning arguments. The phrase "in the interest of justice" is often used in legal settings when an exception or decision is made to protect fairness, even if it bends a strict rule or timeline. Imagine a criminal defense attorney who discovers exonerating video footage the day before trial. Procedurally, it's late, but the lawyer petitions the court to admit it in the interest of justice. The principle is clear. Better to allow the evidence than risk convicting an innocent person. You'll hear this phrase in motions, judicial opinions, and legal arguments. It's a way to signal that fairness, equity, and the integrity of the process outweigh technicalities. Advanced lawyers use this language to appeal not just to the law, but to the higher ideals behind it. To uphold the rule of law means to support and enforce the idea that no one is above the law, not governments, not corporations, not individuals. It's about applying legal standards fairly and consistently, regardless of power or position. Picture this. A constitutional court is reviewing a law passed by a new administration. The law appears popular but violates due process protections. The judge strikes it down, not because it's politically convenient, but because doing so upholds the rule of law. It sends a clear message. Laws must follow the Constitution, and justice is not selective. This phrase is powerful when arguing for accountability, constitutional rights, and legal checks and balances. It reminds listeners that justice depends not on who you are, but on the legal framework that governs all. Let's wrap it up with a story with everything we have learned today. Imagine this scene. A senior employment lawyer is speaking before the review panel of a multinational company. Her client, a mid-level manager, was recently terminated after reporting discriminatory practices. The lawyer begins. Rarely have we seen such a clear imbalance in procedural fairness. By using inversion, she commands attention immediately. She frames the issue as a question of systemic bias, not just individual misconduct. Then she draws a clear distinction between her client's performance record and the circumstances that led to the termination. As she speaks, she uses persuasive language, respectful, structured, and formal, emphasizing legal reasoning grounded in the company's own code of ethics. She anticipates the opposing counterargument that the dismissal was based on restructuring, but she is ready. With a calm tone, she puts forward a compelling case, citing internal memos, performance reviews, and timelines that call into question the employer's justification. She shifts the burden. If the company wished to assert this was unrelated to her complaint, then it must provide clear and convincing evidence. The burden of proof lies with them now. By referencing case law and previous internal decisions that rest on strong precedent, she upholds the rule of law while remaining professional. Her final point resonates. In the interest of justice, she says, we ask that you review this termination not as an isolated incident, but as part of a larger pattern. The panel is silent. She's done more than argue, she's persuaded. And that is the power of language when it's strategic, structured, and grounded in law. Let's take a moment to review everything you accomplished in today's advanced legal English class on strategically framing legal arguments. First, you learned high-level vocabulary, words like rebuttal, burden of proof, and persuasive language that help you describe legal thinking clearly and professionally. Then we worked on two key grammar skills: inversion, which adds emphasis and authority to your arguments, and formal register, which helps you speak with the professionalism legal audiences expect. We also introduced idiomatic expressions used in legal argumentation. These include call into question, draw a clear distinction, and in the interest of justice, all of which add persuasive weight to your speech. Most importantly, you put these tools together to present strong, structured legal arguments, the kind that win trust, respect, and results. Want to continue mastering advanced legal English? Join our community for full course access, live workshops, and personalized feedback. The links in the description. We'll see you inside.